67% of Americans have no will. That means if they die today, they do not decide who gets their money. The government does. A court does. A stranger in a robe does. Now picture two neighbors, same street, same size house, same savings, same young family. One of them spent a single afternoon and less than $200. And when the worst happened, his family was protected and his wishes were honored. The other one always meant to get to it. He never did. And his family spent the next 2 years in a courtroom watching thousands of dollars disappear, while a judge made decisions he should have made himself. Today, you will see exactly what separated Daniel's family from Drake's, and how to make sure you are on the right side of that line. When someone dies without a will, there is a legal word for it. Intestate. It sounds technical, so let me translate it into what it actually means for the people you leave behind. The state steps in, a court takes over, and a judge, following a rigid formula written by your state legislature, decides who gets your bank accounts, your home, your savings. Your actual wishes? They are not part of the equation. The court does not know them and cannot honor them. This whole process has a name too. Probate. And probate is slow. It commonly takes 1 to 3 years to fully resolve. It is also expensive. It typically costs between 3 and 7% of your estate's total value. Let me make that real. Say Drake's home and savings are worth $300,000. His family could lose somewhere between $9,000 and $21,000 just to the court process. That is money that should have gone to his kids, vanishing into legal fees and court costs. And during those years of waiting, the family often cannot freely access the assets. They grieve, and they wait, and they pay. Now here's the part that stops people cold. If Drake has young children and he never named a guardian in a will, a judge decides who raises them. Not Drake, not the person Drake would have chosen. A judge, picking from whoever steps forward in court. Think about that for a second. The single most important decision a parent can make: who raises your children if you are gone, handed to a stranger, because a form was never filled out. This is not a rare horror story. This happens to real families every single day in this country. And 67% of Americans are one bad day away from putting their family through exactly this. Because here's the truth nobody says out loud. Doing nothing is not avoiding the decision. It is making a decision. To let the state decide for you. Now, I want to show you a trap that catches even the people who think they are covered. Even people who do have a will. Because here is something most Americans have no idea about. Your 401k and your IRA do not pass through your will. Neither does your life insurance. These accounts go directly to whoever is named as the beneficiary on the account itself. And that beneficiary form overrides your will. Completely. Let me say that again, because it is that important. The form you filled out years ago beats the will you signed last week. So picture this very common situation. You got divorced 5 years ago. You were responsible, you updated your will to leave everything to your kids. But you forgot one thing. The beneficiary form on your life insurance still lists your ex-spouse. When you die, the insurance company does not read your will. They read the form. Your ex gets the money, your current family gets nothing. And there is almost nothing anyone can do about it. This is the single most common and most expensive mistake in all of estate planning. So let me show you how Daniel handled it versus how Drake handled it. When Daniel got married, he sat down for 10 minutes and updated every beneficiary. His 401k, his IRA, his life insurance. 10 minutes. $0. Drake has never once opened those forms. He assumes his situation is handled because he vaguely remembers signing something at work years ago. He has no idea who is actually listed. And that uncertainty, that I think it's fine, is exactly how families get blindsided. So let me show you what Daniel actually has, because it is more affordable and more achievable than most people expect. His entire plan cost about $150. He used one of several online services, not a $3,000 attorney. Here is what that $150 got him. 3 documents. First, a last will and testament. This names who gets his assets, and just as importantly, it names a guardian for his children. His choice. In writing. Legally binding. Second, updated beneficiary designations on every retirement and insurance account, the thing Drake never did. Third, a durable power of attorney. This one is quietly crucial. It names someone Daniel trusts to manage his finances if he is ever incapacitated, say after a serious accident. Without it, his family might need a court order just to pay his bills or access his bank account while he is in the hospital. With it, the right person can step in immediately. Now, there is one more piece that matters specifically in 2026, mostly for larger estates. The federal estate tax exemption did not shrink, it actually went up, and the new law made it permanent. As of 2026, it is about $15 million per person, or roughly $30 million for a married couple. For the vast majority of families, that number is far above anything they will ever have, so it does not apply. But if you own a business or you have built a large estate, this change affects your planning right now, and that is the moment to bring in an actual attorney. For everyone else, though, hear this clearly. The basics, a will, updated beneficiaries, and a power of attorney cover roughly 90% of what your family actually needs. So here is your action plan. And let me clear up the biggest myth first. You do not need to be wealthy to need an estate plan. You need one if you have any assets, any dependents, or any opinions at all about where your money and your kids end up. That is almost everyone. Step 1. Update your beneficiary designations this week. Log in to your 401k, your IRA, and your life insurance. Look at who is actually listed. Fix anything that is wrong or outdated. This is free, and it takes about 10 minutes. Step 2. Write a basic will. Reputable online services start around $100 to $200 for a simple estate. If your situation is complex, or you own a business, hire an attorney, that runs $1,000 to $3,000, and for the right situation, it is absolutely worth it. Step 3. Name your power of attorney and your guardian. Decide, on purpose, who manages your money if you cannot, and who raises your children if you are gone. Put it in writing. Do not leave the most important decision of your life to a courtroom. Step 4. Document your digital life. Make a list of your important online accounts, your passwords, and any cryptocurrency. And pay attention to that last one. If your heirs do not have the keys to your crypto wallet, that money is simply gone. Forever, no bank can recover it. Estate planning is not really about death. It is about protecting the people you love from chaos on the worst day of their lives. An afternoon now saves them years later. This video is for educational purposes only and is not personalized financial or legal advice. Subscribe. We post every day on topics that protect your money and your family. Next week, we kick off a brand new series on growing your money, starting with how to invest your very first $100, even while you are still paying off debt. See you tomorrow.